Right, good evening and welcome to the live stream for Monday, the 11th of November. It's me, William Flack, here, and my usual guests who should appear in the next screen, but then I've got the wrong. Hold on a sec. Right, good evening and welcome to the live stream for Monday, the 11th of November. Now it's playing that again. It's me, William Flack, here, and right, I'm going to mute that and then go back to this profile live stream, which is this one. So then I'm going to bring in the guests, and we've got Mike, Shannon, and Karis. And I'm afraid again, I've been so busy with casework that I haven't had time to draw up a sort of detailed agenda or even sort of stuff to talk about tonight. But I thought if we just have a chat and see how it goes, if necessary, we can finish after a while. But if if not, we can carry on for an hour if that's okay with everyone. And if anyone's got any questions, please put them in the comments. I can see the comments and I'll put them up on screen. And just to repeat the usual warning, please don't put any personal data. If you've got a question, don't phrase it in the first person. Just imagine it's about a friend or something you heard. So that's my introduction. And has anybody got any news or anything they'd like to say before we carry on?
It did occur to me that given that it's Remembrance Day today, like whether I don't know if it's too tacky, but just kind of talk about veterans and homelessness law. So potentially a little bit about priority need and about armed forces covenants and stuff like that, if we get time to put it on the end there. So I just thought, yeah, as I say, it's just something which I guess, yeah, in people's minds at the moment.
Yeah, I guess we could kick off. I mean, shall we? Sorry, I've got to maximize my screen here so that when I put comments on, that's better. I'll go smaller. Right, so I'll tell you what I wanted to just start off with and see what anybody thinks. But I think we could try and have this. I will genuinely try and do some preparation for this in the future. But I have got a little project I think I'm going to do, which for myself is to learn up about the Court of Protection. And I think the Court of Protection is something that most lawyers and people have heard of, or members of the public might even have heard of it. But it's quite important for dealing with vulnerable people. And the more we know about it, I think the more we can sort of see it as a useful tool for the sort of stuff we do. And what I'm going to try and do, if I go to here, you should see my screen, which was supposed to be more centralized, but let me just drag that up a bit. So I've prepared this page, which I'll put a link to. This is a Notion page, and I'll put a link to it in the show in the details for the show. And this is the beginning of sort of information I'm putting together. And what happened was, I mean, I've dealt with the Court of Protection a few times. In a nutshell, what it is a court that was, I think, brought into effect by the Mental Capacity Act or Mental Health Act 2005. And it was felt that a court was needed to deal with things involving people who lack capacity. And we've got often in our discussions, we've discussed lack of capacity because it comes up in terms of whether you've got capacity to make a homelessness application. But there's lots of other issues that happen, like the most common example is people who have a hoarding disorder. And traditionally, the law would say that the landlord can sort of take possession action against them because they're breaching the terms of their tenancy by making a terrible mess and putting people's lives in danger. But then the law has sort of moved on that the Equality Act means that if you can show that this person's hoarding disorder is a genuine medical condition which is impeding their daily activities, then it's a disability. So you can't evict them just because of a disability. Or put another way, you can, but before you can do that, you have to show you've exhausted every alternative. And the most obvious alternative might be to refer people to social services and say, well, social services can help this person because they sound like they've got needs under the Care Act. That's one option. It can be very slow and very frustrating. Um, but another one is to go to the Court of Protection and say, well, you can get orders. What you really want is the hoarding problem dealt with. And then you need to get like a court order to say how you go about it. Because you can't just get an injunction, because a traditional court's injunction against somebody who has capacity would be you do this, or more importantly, you don't, or if you do this, then you're going to get into trouble and you'll be in breach of the order. And the trouble is usually contempt of court and being sent to prison. But obviously, if the thing's arisen from a mental illness, you can't be in contempt of court. So that presents a bit of a sort of logjam for landlords because they're stuck. They can't do anything, but they can go to the Court of Protection and ask for orders such as, I mean, it comes in, it overlaps with this concept of deprivation of liberty. I don't know if you're familiar with that one, but it comes up when dealing with people with, well, often with mental health problems, because if they get sectioned or put in hospital, or they are they're being deprived of their liberty, which is something that the society takes very seriously, um, and you have to be able to demonstrate that it's justified. And so, if you were to go into somebody's house who's got a hoarding disorder with a sort of a sort of skip outside and a load of people with gloves on, and they say, right, we're going to take everything out. I mean, that could be quite a traumatic thing because it plays right into their disorder. So then the court can actually give very clear directions over all sorts of aspects of it, like who can go in there, when they should go in there, what they're allowed to do, what if the person tries to stop them, what how much force can they use in restraining them. And another issue, I was just listening to the video yesterday, and it covers things like what happens if you've got somebody that is mentally ill and they don't know what's going on, and you're doing this thing to tidy up their flat, and you find valuable items in there. What do you do with them? Because you can't, if you give them to the person who's got less capacity, and they might have them taken off them, or they might go and do something, sell them or something, and then regret it. So there's all sorts of questions which I don't know the answers to all these questions, but I'm going to try and go through this guidance, and in future weeks put more stuff up, which I think would be useful for lawyers and caseworkers and also the public generally. Because I mean, how much does that sound like new stuff, new territory for you guys?
I've heard it mentioned a lot, but as you say, kind of never seen it in practice myself. I mean, if you wanted to get, if you've got any, you want to have a discussion, there's someone I know who might be really useful to have on the panel that night because that's his bread and butter. He worked in the physical disability team for many years and now lectures at uni. So that, yeah, his kind of, yeah, actually knowing your way around the kind of the day to day of how do you actually get,
Yeah.
court protection involved in kind of what does that entail, I think would also be quite helpful because I think, yeah, otherwise it just sounds like all very mysterious to me.
Well, that's right, and it does sound like I think I was talking to Karis about this earlier, and I think most of us have sort of imposter syndrome when it comes to dealing with complicated legal issues, and you think, well, this is for the really clever people, and I'm not one of them, and it looks like I've finally sort of it's caught up with me, and I don't know, I don't understand what's going on, and the Court of Protection is really um, dangerous for that because you can. There's a lot of terms that you don't know, like deprivation of liberty and a capacity assessment, and what is a capacity assessment. Um, so I thought what I would do is create some basic stuff so that people can take part. We can then have a discussion with people who know what they're talking about. And I was hoping to get some barristers as well. But at least we can fall back and say, look, if you're having trouble knowing what the hell we're talking about, go and have a look at these basic things, which I've done. And so far, if anyone wants to see them, we've got a very short video here, a longer video here, which lasts about an hour, about what is the Court of Protection, and now what is their role in housing cases. Um, and then you've got, if once you've really mastered those two, I would say, and you've maybe read the guide here, that I've got, the simple basic guide to the court of protection, which is a free PDF. You can then go on to this one, which is the advanced one, which is the masterclass by Cornerstone. And I think if you knew all of these things, you'd be pretty handy when it comes to actually what to do for people with mental health problems. And I think the thing with this type of area is that the more you look at it, the more you can expand it creatively. Because at the moment, it's like the Children Act. When that came into force, that was meant to protect, sort of codify all of the law relating to the protection of children. But it was the usual suspects that children were being protected against, so people abusing them and stuff. It was only later that it became a useful tool in housing law, which nobody had imagined, that you could say that social services and children, what became children's services, had to start housing people when they fell through the cracks of the Part 7 of the Housing Act. And this was particularly true when the government started trying to deny housing rights to migrant groups. It started with Michael Howard back in 1995, and remember the concept of bogus asylum seekers. And so that was really, really useful. And I think this will be useful as well, because if you talk about what support people need in maintaining properties, some people may say, well, there's just no way they can live independently. But you can say, well, there is. And if they cause problems, you can always apply to the Court of Protection. So
Can
that's what I'm going to say about that. Oh, yeah. Did you want a
can
question?
yeah, I just got it's probably a silly question, but obviously I know nothing about court of protection or anything like that, but I know that a lot of workers in the homelessness sector would struggle to do like a capacity assessment, or they'd get like basic things wrong. And I guess this all sounds wonderful, but are the lawyers who are doing this stuff, are the people that are involved in this other process around capacity, are they, because capacity is not just homelessness, like there's capacity issues in other areas as well. So are they trained in sort of like making capacity assessments, etc., particularly in this cohort of people? Or do we see the same issues around capacity assessments even in this field of assessing, if that makes sense? Or is it genuinely a better option than like your average capacity assessment, etc.?
Well, there is the problem that you've got, I think, that comes up time and again. You can see it in priority need and the evaluation of medical evidence in the more things we're more familiar with, is that you've got people who aren't qualified and don't know what they're talking about necessarily, trying to make decisions, and they can either, in theory, say a local authority should be doing an assessment of somebody's vulnerability with the assistance of a medical advisor, but because they don't know how to do it, they'll usually devolve the whole process to them, say, please, will you make the decision? But the question of whether somebody's vulnerable isn't really a medical question, it's a legal question, based on medical issues. And the same thing applies to capacity, because um, there's, for instance, I deal with capacity in a slightly different context, where somebody, so I was dealing with a case today where somebody lacks capacity to manage a tenancy or even to instruct a solicitor. Those are the two key things. Now, I I'm not a specialist. I was talking to somebody. I had to have a very quick conversation with them, just because if you start saying I'm going to run your case based on the fact you've got mental health problems, some people may say, sort of, no, you're not. I don't give you permission to make those sorts of comments about me. But I said to her, I'm not qualified to do this, but I know that legally it sounds like you're fitting into this category, and I'm going to have to get a psychiatrist's report. But if I've done a letter to the landlords, and I'm saying to them, I think this person lacks capacity, and I'm pretty sure I'll get a response, which is quite common. Say, what a load of nonsense! They manage. It's the old vulnerability thing. They managed to get to the office all right last time they had a meeting, so they must have capacity. The fact that they don't remember what happened at that meeting doesn't occur to them. So you get a lot of people, but ultimately, if you, it's for the judge to decide. And
So, in terms of practice, then, because I don't know if I'm just being slow tonight, which is possible. It's a long Monday. If you had a client who, say, like the housing officer was like, nope, they have capacity, what are you chatting about? That's when you could then go to the court of protection, did you say?
well, you could, yes, although you could just go to a normal court, because what I'm doing is I've got a county court case
Okay.
where the person is facing eviction through bailiff's warrant. And the only defence I've really got, well, I've got two levels of defence because there's massive rent arrears. And on the face of it, if they haven't paid the rent and it's that high, it's difficult to argue that it isn't reasonable to make a possession order unless there's some medical type issue where you can say, well, it's not their fault or they didn't know what they were doing. So the first half is to establish a disability, and the second is to say they lack capacity, not just to manage their tenancy, but also to be a party to legal proceedings. And that's that has a magic effect, or like it's like a sort of cartoon movie where you've got some sort of gun that freezes everything. Because as soon as you say the words capacity, and you give the judge reason to believe this person lacks capacity, then they can't make any orders or do anything that would be contrary to that person's interests.
And is that, sorry, I feel like I'm just firing those questions at you. Is
No,
that
please do. I mean,
reasons to believe threshold as low as it is when you like make a homelessness application?
well, yes, I think so. Well, in
Yeah.
terms of the judge, yeah, because say, for instance, there's this dilemma you get with mental health, which I struggled with for a long time, but I've come to terms with it now, which is how do you, if you get instructed on Monday and somebody's going to be evicted on Friday and you haven't got any medical evidence and you just got a client who's clearly confused and the problem is you go to court and say they lack capacity and you will get a lawyer from the other side saying, what a load of nonsense, not a shred of medical evidence. Where's your medical evidence? But of course, many people with mental health problems don't engage with medical people, and also GPs are notoriously bad at dealing with mental health issues because they are not trained. Do you agree with that?
I was smiling because I had a follow-up question already.
Oh, right. So
So
just
where
yeah, go
go
on.
on.
So what I was going to say was I put in a statement. I say and this is, you have to risk sounding a bit arrogant, but you say I'm a solicitor. I've been doing this for many, many years, and so although I'm not qualified to make medical diagnoses, I know I've come to recognize mental health problems when I see them, and based on my experience, I'm pretty sure this person lacks capacity because when I asked them what day it was, for instance, I mean, this is it's usually much more complex. They didn't know, and when I asked them who the Prime Minister was, they said it was Harold Wilson. So therefore, I think they're not. But it's usually more complex. It's just like they can't remember important things which they should remember, and then the judge would say, "Well, okay, I hear you, and I'm going to give a direction that I'm going to adjourn this until we can get a psychiatrist's report." The only problem is that can take about 3 months, but you shouldn't be afraid to ask for that because very often the report will come back and say, yes, they lack capacity or they've got a disability. Sorry, what was your follow-up?
It
If
was
you can
going to be
remember.
yeah. So one, I'm assuming that would also work then for in cases where people have got fluctuating capacity, because most people will have fluctuating capacity, not just like no capacity ever. But it was around when you said like the other lawyer will obviously be saying like rubbish, they don't have capacity, they're absolutely fine, etc.
They do have capacity, yeah.
But what's the accountability there? Like, how can you, like, is there any accountability that you can then hold upon that lawyer that's saying, or like whoever's the representative of, say, like a housing association, who's obviously chatting rubbish by saying this person has full capacity, they're fine? Is there anything you can do to sort of like stop that? Because that seems to me like bad practice, because if we're talking about people that lack capacity, they're some of the most vulnerable in society and we should be protecting them. And like, I don't know anyone who like has fluctuating capacity that would take the piss with that either. So I'm a bit Yeah, there might not be anything, but I'm just interested in. I'm
The
rambling tonight. Sorry, guys.
no, please. I mean, it makes the conversation. I mean, if nobody asked anything, I think, oh, that was that then. But the accountability, I think, is that they can look very, very stupid at the end of it. So now you may think, well, that's really bad, isn't it? I mean, that's not going to scare them much. But there's a case which I can put a link to called, which I think I've mentioned before, called Rosebery Housing Association. And I've forgotten what the name of the other person was. It's actually Sarah Steinhardt, who is we all know from your videos, was the barrister on that case, and she got a fantastic, and also Jan Luber, who was the judge, and there was a fantastic case where the Land Housing Association had been discriminating against a neighbour who had mental health problems. And it wasn't so much about capacity, but it was about them refusing to accept she had a genuine disability. And at the end of the case, they were ordered to pay £37,000 damages to her for the distress caused, and the costs would have been probably as much as that, maybe twice as much as that again. And somebody somewhere has got the reputation of being that where Rosebery Housing Association's name is now associated with disability discrimination, and there's going to be a housing officer within there who's got it. They were the officer responsible for that, and I think that's about as good as it gets with accountability. And
I
maybe
guess like when you've got people that are like maybe denying capacity issues, then discrimination is quite likely to go hand in hand with that, because they are probably also ignoring other accessibility needs, right? Like as a housing association, they're probably not taken into. Okay, cool.
And what's happened is I think we were talking about the psychological issues in these things, and by the time you get to the stage where possession proceedings have been issued, or an injunction's been applied for in a hoarding case, the mentality of the staff and the housing association or the local authority has sort of crystallized or frozen to the point where they have decided that this person is the enemy, and therefore it's legitimate to do whatever it takes to fight the enemy, and therefore they're not going to consider, because twofold. One is they've already made their decision and they're going to justify it, but the other is if they're wrong, they look stupid and they can't really say, "Oh, all right, then we've done all this and wasted all this money." So you're stuck there with that, and so yeah, so capacities, and you're right that the fluctuating thing's important, but also there's this nightmare thing that capacity is issue specific. So you could have capacity to do X number of things, but there could just be one thing that you hate. Is somebody's got a mental condition, which means they hate the gas company, and they will not let them come in to inspect, which is a common problem, and where people go for injunctions and threaten possession action. But so you could say that they're okay on everything else, but they just lack capacity on that. But it all turns on the psychiatrist, and how they assess, really. Although you can get other people to assess, like social workers can assess, and GPs can assess if they want to, but they're mostly scared because there's quite a lot that rides on it, and so they don't want to make the wrong decision. So I'll try and put some more in there. I mean, there's stuff about how do you measure capacity, and what are the signs, and also how do you instruct a psychiatrist. And the danger is there's lots of practical dangers. Like psychiatrists tend to be quite battle hardened, so they tend to only recognise mental health problems when they're quite severe. Some of them. So if you're not, because they spend their time on a sort of ward where people are being detained, they're used to people being really out there rather than just suffering from what I think is important is like debilitating levels of depression, where you may seem fine, but if somebody sends you a letter and it looks like it's from the council, you put it behind the radiator in the hallway where it stays. But that's as serious as anything. I just see if this comes in. We've got a very small comment here. I'll try and make it bigger. from Cheeseface. Hello, Cheeseface. Welcome to the show. But I'm trying to make your comment bigger. Forgive me. It should be this screen here that I go to, but I can't. Oh yeah, there we go. It is this one. So if I just bring that up, and then we can make it a bit bigger. And so Cheeseface's comment, X's housing officer outright told X that X didn't have a disability, mental health, mobility issues in an email. Yes, it's discrimination, but how do you get listened to about this? Yeah, it's true. I mean, it's like with priority need. If somebody decides you're not vulnerable, you can't really say, yes, I am, and here's a letter from my doctor, because they probably say, oh, well, your doctor, they'll then do the sort of old now medical trick. Oh, your doctor only says you're sort of severely depressed. He doesn't say that you had to be referred to the psychiatric unit because of that, and you haven't. There's this horrible term that gets used. You've got a history of suicidal ideation, but you're not actively suicidal. And I think, God help us, what does that mean? I mean, does that mean you had to be sort of attempting suicide when they met you or something? So I think Cheeseface, the problem is you always get that. Once somebody's sort of made a decision, then Mike, what's the psychological term? You've used it before. It's really good about people who've made a decision. It's like confirmation bias, isn't it? That's the one I'm looking for.
Yeah, the agentic state.
Agentic state, yeah. So does anyone else want to say anything about capacity and stuff?
Well, I've got a question kind of building on Cheeseface's question there. So you mentioned a case before where someone gets 37k compensation for the distress caused by denying someone's disability. How could someone in an everyday situation like the one Cheeseface is talking about there, how could they go about essentially? I mean, is there a route for them or a pathway to actually get a solicitor, get a barrister or whatever, actually arguing that point? And because I'm sure you can go to the LGO and the LGO will probably maybe recommend a few £100 or something pretty petty. But if you can get to court on discrimination, it's prompt money, isn't it?
Well, it depends. Let's put the comment back up again, but it depends what else the housing officer did, really. Because if they're just having a conversation, I mean, sorry, it sounds silly, but if they're just having a conversation and the housing officer says, I don't think you have got a disability, but there's nothing material about that, and they say, well, but if obviously the conversation was in the context of you haven't been paying your rent, and now you've got £5,000 rent arrears, we're going to evict you, and the tenant says, I've got a disability, I've got these conditions, which, I mean, it's quite rare that people would say I have a disability, but they might describe a situation which somebody knowing the definitions would say, well, that sounds like a disability. But if the conversation then becomes really important, because the tenant, often landlords will respond if they get caught out in a disability discrimination situation. They'll say, we had no idea that this person was disabled, and it's the first we've heard of it. Even though they housed them, they were referred by local authority as a vulnerable single man because they had a history of mental health problems. I've got one which is a hoarding case, and she was actually transferred to the new accommodation she has because her previous accommodation was so badly hoarded up, they thought they'd just get her out of there and give her somewhere else. And then they said, we've got no reason to believe she's got a hoarding problem. But once they've said something like that, you've got the sort of, you can hold up this, you've got the silver bullet to say, well, not only did you know about it, but you actually denied it. And that makes it worse as well, because you then have injured people's feelings. And that's when the sort of meter for the compensation really does start to run. And it is difficult for landlords to say they didn't know something, because you can obviously turn a blind eye to people's mental health problems and say, we didn't, and you get daft things like saying, well, there's nothing, I had a case once, actually, it was a barrister that said this, but a client of mine hadn't paid the rent. She hadn't claimed housing benefit because she believed that the government had abolished all benefits for people, which I said, I think that's such a crazy suggestion that it indicates a delusional state. And the response I got, no, that's a perfectly rational decision. You could think that the government has abolished all benefits. But actually, then I got a psychiatrist report, and it said that she'd got a really serious psychotic condition, which meant that they never did get her out, and it rattled on for many, actually about 4 years, that case afterwards. But it all worked out in the end.
So,
So
so Will, is it something that kind of comes in your kind of day to day, your kind of casework that you're working on a homelessness case? If you were to come across a situation where there appears to have been some kind of, perverse denial of someone's disability, or some kind of, some kind of treatment which is yeah, kind of, beyond the limit of kind of an honest mistake or something, is that something you would be able to include, or kind of, I don't know, how does it work? Did you kind of do you kind of refer it to a barrister? Does the barrister take that
well,
issue on, or?
it comes up in a different way in the homelessness situation, because in a possession action or a hoarding injunction or something like that, or a neighbour nuisance injunction, West Rosebery Housing Association was a neighbour nuisance thing because the tenant's disorder meant that she felt compelled to be filming the neighbours with her mobile phone all the time, and obviously they felt this was intrusive. So it's usually that you're taking some adverse action against somebody, either trying to evict them, trying to get a court order, trying to get them sent to prison for contempt. Whereas in a homelessness case, you're just refusing to do something for them. Usually, you're saying, "Well, we're not going to give you accommodation." They don't. It's more difficult to say that they discriminated against you in the sense of they refused to give you temporary, or they gatekept you, or they said you weren't vulnerable. So it doesn't come up that. Where it comes up is that you say that they failed to consider a disability. So the most obvious one would be not necessarily vulnerability, because you can be disabled but not vulnerable. I mean, conceptually it's possible, but it's more intentional homelessness. If they say you deliberately did something, but you were actually suffering from an illness that led you to do that thing, or you didn't pay your rent, we're back to the sort of same arguments you get in a possession case. Then you could say, well, you've discriminated against the person by not considering their condition. But it's still difficult because they're not actually actively taking action against somebody. They're just refusing to do something positive, which may sound pedantic, but it's difficult to say that they're discriminating against somebody. They're just failing to recognize it. And the nature of homelessness challenges is that you're just saying, look, this is where you screwed up, but we're not saying it amounts to disability discrimination. So it'd be quite. Also, the problem is that the claims that you get, judicial reviews, the High Court hates getting involved in compensation claims in judicial review, and Section 204 appeals. You wouldn't really put in a financial counterclaim in there, so it's difficult to recover that. But you could make a complaint and then go to the ombudsman. But for reasons we talked about, lawyers don't tend to do that because we don't get legal aid for it, for one thing. So that's the answer to that. But I'll try and come back.
I know it's
yeah.
sorry, I know it's a slightly different situation to the one Cheeseface is talking about, but I've found it in my personal situations with support workers. When I mention that this disability is protected under the Equality Act, so you have to make this reasonable adjustment, otherwise I'm going to have to pursue discrimination. It is an Equality Act legal thing. When I've explained that to support workers and stuff, most of the time, not all of the time, but most of the time, they'll then start making the reasonable adjustments you've asked for. And it's really weird because I've sat in lots of assessments, I don't mind talking about that, for mental health and stuff. And they've talked about my mental health, they've talked about the stuff I need to, have changed around that. And then they don't take it seriously. And then the minute you pull them up and go, okay, we had an assessment where we talked about this, but now I need to highlight the fact that this wasn't just an assessment form, this is a legal duty you have to do now. They go, shit, okay, didn't realize it was that serious. And then they sort of cop on most of the time.
Well, that's good. Maybe you have the advantage of getting there earlier in the day than we do, because by the time lawyers get involved, the sort of everybody's got their sorts you know, they've made their decision and they're sort of stuck and the wheels are already turning. But the response I tend to get is the usual sort of, "What a load of rubbish! You know, you're just trying it on." And that can often, once you get the psychiatrist report, though, if the psychiatrist report says this person's got a disability and you know they've been suffering from it for since before this began, I think they then the lawyers then can hang a hook. They can advise their clients to drop the action because there's now a new reason which they weren't aware of when they advised them to go ahead with it. Like I say, in the light of this evidence, we'd say drop it, but it's quite difficult to get to that stage without medical evidence.
Can I ask
Caris,
something
yeah.
else? Sorry. Is there any onus on the local authority, particularly when they're going to court in that pre-action stage, if there's had assessments and things like that, then to have reasonable adjustments all the way through a court proceedings when they're handling that, you know, before action letter and the
That's a good
court proceedings? What onus is on them to make sure they've done any reasonable adjustments, or is there none, particularly around capacity?
Well, I was just going to go into
Processing.
this. So the answer, I think, lies in this pre-action protocol for possession proceedings. They should try to contact the client, the tenant. Forgive me, I should go through this. I mean, for those of you who are not familiar with this, there is a pre-action protocol that social landlords are supposed to follow before they take action against tenants, all tenants. I mean, it's not just disabled ones, but the idea is partly that they will, by following this protocol, they will be able to identify issues which they might not otherwise have done. And so it requires, let me see, possession claims based on rent. There's initial contact. It gives a thing. So it says, if a tenant falls into rent arrears, the landlord should contact the tenant as soon as reasonably possible to discuss the cause of the arrears, the tenant's financial circumstances, the tenant's entitled to benefits and repayment of the arrears, and where contact is by letter, the landlord should write separately to each named tenant. Now, the problem is that it's traditional to serve, and you know, you've got to serve a notice to quit or notice seeking possession. So a lot of landlords will just say, well, we sent them a letter. But it doesn't say here that they should contact them by going and knocking on the door and saying, is everybody all right here? But I think, and it may come down to looking at the details further down, but I think the onus is on the landlord to show that they've made reasonable inquiries and they haven't just gone through the motions. Because if you've got a client, if they've got any reason to know that that person has mental health problems, which they probably have, even the fact that they're not answering letters which say we're going to chuck you. There are people that just say, I'll just ignore letters just for the hell of it until I don't get away with it anymore, and then I realise they've issued proceedings. But it's often a sign that the person isn't well. So I think but the key thing is where they get into trouble is when you fill in a particulars of claim or a court possession claim form. There's a section where it says, and you may not have noticed this, everybody, but it says about the claimant, about the property, and about the defendant on the form. And the landlord is under a duty to tell the court anything relevant about any of those things. So if the landlord's file shows that they've got some knowledge that the tenant is disabled and they don't put it on that form, then they're in trouble. And you can then say, look, they've misled the court. They haven't checked their own records. Normally it'd just say the claimant, the tenant we believe the tenant lives in the property and we understand they're in receipt of benefits, and then it'll say, what steps have you taken to contact them in accordance with the protocol? And it's just say, we've written to them on numerous occasions, but you can be pretty sure those are just computer generated, we're coming to get you letters rather than are you all right letters. I think that's the answer to that question, is that there is an onus on them to to take steps. It's not quite as strong as Section 184, where you actually have to make positive inquiries, but it's something that you can use, and especially if you can later show that they knew about this and it's not in the beginning and they haven't put it in the claim, then they're going to have difficulty pursuing it. Any more questions about this one?
Yeah, a couple of things kind of circling around. So on that point, I found the LGO to be quite weak. When I remember a case where we very specifically, I mean, both the parent and the child had significant disabilities, and we kind of not only told the council from the off, but also stated what reasonable adjustments we thought should be made, and they were, they're reasonable requests basically, and the council had it on file that they'd had that information, and there was no further assessment or kind of contemplation of it, and the LGO still didn't really do anything about that, which I was really, I was quite disheartened by, really. I mean, on the rest of the case, that the LGO was actually really good, but so I think that's, because I always sort of tell people, make sure you tell the council that you've got a disability and what it might be and what you need to do about it, but the LGO on that, certainly on that occasion, weren't particularly helpful.
Yeah.
Kind of just circling back to capacity. I mean, first of all, I think it's a really fascinating area we should probably talk about more, because you've got interesting kind of interactions. Like let's say you've got within intentional homelessness, you're not intentionally homeless if the act arose from a temporary aberration of your mind caused by a mental health issue or substance use issue, whatever. So you clearly that kind of takes into the idea that you might have lacked capacity at the time you lost your accommodation, but that doesn't prevent you from necessarily prevent you from making a homeless application in future. And there's that whole question of what do you actually have to have mental capacity for when you make a homeless application. And the fact that your last tenancy didn't work out doesn't mean you don't have capacity to do it again. But the final thing I say about it is I remember just all these conversations got me thinking. When we did the FOIs earlier this year on the training staff got in councils, the training housing officers got. We did like 15 councils, and I can't think of a single council that their staff got training on Mental Capacity Act at all. Making assessments, doing whatever. So it seems to me pretty much a pretty kind of an omission that often housing officers will have had no training at all, and they'll use terminology like, oh, they lack capacity as a general term, as if that's an appropriate way to use it, where obviously it's not. So I think it's one sense, positive. It's something which if you come up against a council, one of the things in your complaint, you can just basically say, I think your team should get training on the Mental Capacity Act, and that's probably going to lead to some improvements more widely. So
definitely, and I think training for everybody concerned, just about the practical issues of mental capacity and mental illness and how it relates to these things, because there's all sorts of question marks, like how do you apply for legal aid if you legal aid is based on the sort of assumption that you're in perfect mental health and that you can answer complicated questions and provide proof of income. But if you have a fear of disclosing information about yourself, then the legal aid agency have to make adjustments, and so it goes on. So yeah, I'll come back on that one. I'm glad people are interested in it. And I think if we look into the future, I think we can see that the way that looking backwards to start off, I sort of started doing this stuff in the early 90s, and mental health just wasn't an issue. I mean, it just didn't come up, and disability. It's the same way that you think all those people came back from the First World War with loss of limbs and things, and access to buildings wasn't really considered. They weren't building ramps, I don't think, like they did later. So it went through years of not being recognised. But I don't know where it'll go, because I think we've had this problem with sort of talking about supported accommodation, which sort of becomes a bit like filling the gap where sort of asylums used to be. I mean, I'm not saying they're the same thing, but there was an idea that if you couldn't engage in society because of a mental illness, you could live in an asylum and be, it wouldn't necessarily be like it being in a prison, but you could go out and walk around, but you'd have be closely supervised. And maybe it was too authoritarian, but in the future, I think the whole of the welfare state has got, and the whole of the society has got to recognise, right through from crime. I mean, so many crimes are basically down to mental health issues, which are not properly diagnosed, and we still haven't learned the difference between morality, how we judge things as to whether somebody's ill. If they do something terrible because they're ill, is it still terrible? Should we punish them for it, or should we let them off? There's that sort of concept. But with this sort of thing, you've still got that idea within the welfare state that I've said it before, there's no such thing as poverty. There's just people trying it on. And that sort of applies across the board. So there's no such thing as mental health. There's just entitled people who they've learnt a few buzzwords off the internet. And so you've got to fight against that. But I think we'll learn how to get the balance right in the future, probably long after I've stopped doing this. I think it'll take another generation or two, but we're moving in the right direction. And you probably had enough of listening to me rambling on, but I wanted to just share with you an experience I've had this week in a homelessness case. And I'm going to name the council, but I'm not going to name any officers, and I'm not going to name the client, obviously. But it's an example of, we've often had this conversation about the mental, I think I can use the term cognitive dissonance that takes place, or just the mental gymnastics that housing officers do to get round the Section 188 test. Because they'll say, you write to them and say, this person's just got out of hospital and we haven't got a medical report, but it sounds like you've got reason to believe. And especially if you haven't done the inquiries yet, if you did your inquiries, you'd probably find that they were vulnerable. And they say, oh, no, haven't got reason to believe that because we need proof. And you say, oh, no, it's not reason, etc. So this week I had a case where somebody had... and it's usually single males who the councils tend to think by default not vulnerable because they haven't got kids. But so somebody with no young man applies to the council. He's got a history of problems with his family, and he's been living in the family home, and he's been arguing with them a lot. And finally, his dad said, "We just can't go on with this. You've got to go." And he's also got mental health problems and physical health problems. And he applies to the council, and they don't make any inquiries. He brings a couple of letters with him from the doctors saying this man needs help, sort of thing. And they then refer those letters to Now Medical, who do the usual sort of, well, he's not dead yet, so he can't be vulnerable. And then they basically copy and paste that. Oh no, what they do that's worse, they put him in a hotel for a bit, and then he gets a call from the hotel management on a Wednesday saying, you've got to leave on Friday. And that's the first he knows of it. So he rings the council and they say, oh yeah, sorry, we've assessed you as not being vulnerable. And he says, well, aren't you supposed to put that in writing before you cancel my accommodation to let me know the outcome of your inquiries? And they say, oh yeah, sorry about that. We'll do that. So Friday he gets a letter, the same day he's got to leave. You give him 2 days warning to leave. Friday he gets the letter saying you're not vulnerable. It's a really bad letter. And of course, they haven't properly considered, they haven't done the inquiries into his medical condition. They've just adjudicated on what evidence he's put forward. They've just sent it all off to Now Medical, who've arguably not done the right thing. And plus, they've done no housing needs assessment, as far as I can see, for 189A. So they haven't really had a proper think about his circumstances. Plus, they've missed the key point that he could well be vulnerable because he's become homeless due to domestic abuse, because he doesn't have to have been physically assaulted by his family, but if they've behaved in a controlling way and caused him distress, then that falls within that. So I then do the thing I have to do in that situation is I send them a letter requesting a review and setting out representations along the lines I just said as to why the decision's wrong. I then have to send them a second letter asking for temporary accommodation pending the outcome of the review. And then I have to send them a judicial review pre-action letter threatening to take them to court if they don't exercise their discretion to accommodate pending review in his favour. And they extend it, he was due to leave Friday, they extend it till Sunday night on a Friday because somebody was on leave or something. Monday morning, the hotel say, no, you've got to go again. And this is an example of the sort of Orwellian Kafkaesque nightmare that is homelessness. So he says to the homeless people, so he says to the hotel management, could you tell me who it was that's told you my booking's cancelled, so I can contact them? Oh no, we can't disclose that, it's confidential. And then they about 2 o'clock in the afternoon, they complete the review, and the reviewing officer sends a letter saying, yeah, sorry about that, I've quashed the decision that you're not in priority need, and I'm referring it back to your caseworker. But somebody else sends a letter saying, an email saying, well, yeah, we've withdrawn the decision, but it wasn't because we didn't agree with the decision, it was just the wording of the letter. So we're not going to give you any temporary because we haven't got any reason to believe. And I'd written to them and said, surely if you've just withdrawn a decision that somebody isn't in priority need, you must have reason to believe they're in priority need. And so they then say, to make matters worse, they say, while we're rewriting the letter, have you got any further representations or evidence you'd like to put to the caseworker? And I thought, well, surely if it's just the letter, you could have changed it before you'd even written your further letter. You'd say, sorry, we got your name wrong in the first letter, so we changed it. Here's another one. But no, they're still doing that. Oh, and so I'm going to have to try and go to court tomorrow to get an order requiring them to house him, on the basis that they don't recognise they're under a mandatory duty. As soon as they've withdrawn that decision, it doesn't matter whether they withdrew it because the letter was badly written, until they've done a new one. And the last thing I'd say is, we talk about access to councils, and I say there's a telephone number you can ring, but I haven't rung it because I don't want to be accused of making a false application. But today I had to ring the number because when you apply for an urgent order and judicial review, the judges may say to you, well, what did you do to ask the council? I mean, you've sent them an email threatening the action, but did you actually try and phone them or find out what was happening? So I thought, well, I better do that. So I rang the number, the urgent one. It took me 1 hour and 35 minutes before somebody picked up. I was holding for that long. I was number 7 in the queue. And then I got through to somebody who told me she couldn't discuss the case with me because there was no they couldn't see a form of consent. And I said, but I emailed it to you with my pre-action letter last week, and I've got an automatic response from your email address saying you got it. Oh, well, I can't see anything on the system. And so admittedly, the system obviously doesn't absorb things that they get sent, so the person on the phone can't see it. But it's just like your video, Mike, about the woman who went to 3 different social workers and got told they'd take the kids into care because she was homeless. It's amazing how you think it can't. You think no, they wouldn't do something as daft as that. But it's just time and again they just keep ticking the boxes. And if you saw the letters that they're writing, it's just sort of, the one saying we're not going to give you accommodation, it's just sort of gobbledygook, really. Well, having said that, I may get the barrister saying to me, what are you on about? Well, there is no case here, but I'm pretty sure that they've screwed that up. But I thought I'd share that with you because it was very frustrating. But
which council did you say it was, Will?
That was the London Borough of Harrow.
Okay, I was interested to know, like, how common that type of practice is, and effectively who you were talking to, whether they really did know what the law is and they've just been difficult, or whether they genuinely just don't know what the law is. I mean, I think you're absolutely right, by the way, in terms of if they've withdrawn a letter, if they've withdrawn a non-priority decision, then there's still reasons to believe you might be in priority need, because they're still asking a question, basically.
Well, logically, yeah, but even if you go beyond that, you say, well, it doesn't really matter. There's no section 184 notice, it's been withdrawn, and you have reason to believe in the first place. But yeah, I mean, it was just crazy. But I think that's very common. Sorry, go on.
No, I was just going to say, are they still ignoring the domestic abuse as well?
Well, they said that I think that they're struggling with that, and it might be quite an interesting case because in the one of the letters they did send me an email rejecting my initial submissions, and they said, well, we spoke to his father or something, and it wasn't along the lines of his father said they haven't abused him, but it was when something happened there was no signs of abuse. I mean, I won't try and dig it up now and read you the terms. But it was really terrible, because obviously domestic abuse is a complex issue, which you can't just sort of say, well, we had a conversation and we couldn't see any signs of it, even though we weren't looking for it.
They contacted the abuser.
Yeah. Oh, and I tell you another thing that was scary for the client is that he was really worried, and I don't blame him, because on the face of it, it does look that way, that a lot of local authorities sort of broadcast the fact and put it in their tenancy conditions that they will have zero tolerance for domestic abuse. And therefore, if you go to the council and say, my parents I become homeless because of domestic abuse, then you think, oh dear, that's going to result in my parents being evicted, because they've got zero tolerance. And it's the same words. And I've said, no, I think domestic abuse it's an overlap in terminology. Nobody's going to evict you because you are considered to be too controlling or unsympathetic to your son's medical condition. It's more the traditional domestic violence. But I don't know what people think about that. I've never heard of anybody being evicted for that. But it's scary that if you're saying that they should be considering, it's going to scare people off reporting domestic abuse if they think that it's going to make their family members homeless.
No, but it is an interesting way that, so like local authorities, I think Bedford said it recently, where they're trying to obviously keep the survivor of domestic abuse in the household and try to move the perpetrator. So actually, it could become useful in terms of removing the perpetrator if the council or the housing association was like, we've got a zero tolerant policy on domestic abuse, you have to leave the property.
Yes,
I don't know how that would work in like
that's
practice,
good. But I think, would you say that the abuse there is the old-fashioned meaning of the word abuse?
But then they haven't updated their policies, have they?
No.
Like it doesn't necessarily matter what we believe they believe. Like if they've used the word abuse, there's a whole, or they've used the word domestic abuse, there's a whole legal definition of domestic abuse now, whether they meant domestic violence years ago or whether they mean controlling and coercive abuse more recently. Like they need to update their policies if that's not a reflection.
Yeah,
that's me being pedantic, and I've not used it or seen it be used, but
well, I don't think there's been very much case law on the question of what is domestic abuse within this wider context. But it's important, especially where it gives rise to vulnerability, because obviously councils are just, they're bad enough when it comes to medical conditions. But if they're not going to consider it,
well, it's separate to vulnerability, isn't it?
You can be vulnerable, or is it? Sorry, are you vulnerable, or are you just in priority need?
You can be in priority need if you are currently fleeing domestic abuse, but it doesn't necessarily mean that you're vulnerable.
Oh, right. I thought it was. I think. Let me just check.
The wording is you're in priority need if you're homeless because of domestic abuse. You don't actually have to have fled. But then you've got a standalone category where if it's historic domestic abuse and it's not the reason you're currently homeless, then it would still be relevant. But you'd look at it as an issue of vulnerability rather than an automatic characteristic.
And the domestic abuse just has to be likely to continue, right?
So I think the side case, so section 177 talks about you're homeless if it's probable that. So it's really weird how I would say the way you would actually read it is that remaining in your home is going to probably, as in more likely than not, going to give rise to a risk of continued domestic abuse. I would say that's how you could, if you look at kind of put everything all together. So whatever that means, it doesn't kind of then specify like what risk, how high risk is it. If there's a risk and it's probably going to continue, then you'd be homeless. But I've not seen that kind of level of detail. There's some real kind of lack of clarity. There's a book I'm waiting to that's coming from Legal Action Group called Domestic Abuse and Housing, which is not.
Oh yeah,
I think it's missed its publication date by the look of it. But I'm really hoping that they go into that kind of level of detail within the book, because it's not. There's just this kind of like, it's just not been set out, and you've got some pretty dodgy organisations I saw over the weekend who are kind of putting out information which I would think would be quite suspect and in favour of local authorities. But
and the Homeless Code of Guidance says it's used or threatened violence against you. Is it?
It's so the code of
really
guidance
broad.
again. It's kind of like it still uses the term domestic violence at points. So it's kind of this weird sort of like limbo state where it hasn't updated everything. And so yeah, it talks about kind of violence or threats of violence which are likely to be carried out still, but that still means the wider definition of domestic abuse. It's kind of, they just haven't done a very good job of making it all line up, to be honest.
But if you see section 189, which I've put on the screen there, if it's big enough, and it's in square brackets because it was introduced by our very good friend, the Homelessness Reduction Act. And they've introduced this new category saying a category of priority need is a person who's vulnerable as a result of that person being a victim of domestic abuse. So in that sense, it wouldn't have to be ongoing, because I could have left home because I just couldn't put up with any more rows and what I considered to be abuse, and what somebody else may agree was abuse. But once I've left and I've become homeless as a result of that, then I've thought the wind changes and I'm in priority need.
It would cover both people who have fled their most recent accommodation, but it would also include people who are currently living in that accommodation still. So the point being that you don't have to flee. So as in, you don't have to take your suitcase down to the council to make an application. You can say I'm living in my home and I'm at risk, and that would be enough. Because it's not reasonable to continue to occupy
that's a sort of separate test, isn't it, for whether you're homeless, and it crops up in the local connection thing if you'd be at risk, because local connection is at risk of violence, isn't it?
Is any
or is it any abuse?
It's any risk. It's risk of any abuse. But
oh,
again,
right,
you've kind of got this. It's not very clear when it's talking about domestic and non-domestic abuse. But that the definition of homelessness itself, as soon as that's satisfied, the priority need automatically kicks in.
It needs clarifying, doesn't it? Because if I was a housing officer, I would say, well, this is just madness, because as soon as somebody has enough rows with their parents, if they're an adult living at home and they sort of say, right, that's it, I'm off, I can't take any more of this, they're homeless, they're in priority need, and arguably they can apply to a different authority. Is it, or is that?
I would say that there needs to be something more than just having a row and being asked to leave. I think there needs
to be, I'm looking at it from their sort of cynical point of view.
So I think that's really kind of the question which isn't very well answered in certainly the documents I know. It doesn't really say at what point does that dysfunctional relationship become domestic abuse. And Jan Luber puts it quite well. He says it's domestic abuse when one person's become a threat to the other. But that again, it's incredibly difficult for a housing officer to assess that, particularly when they've got, first of all, they haven't had training, and secondly, they've probably got a horrible boss breathing down their neck telling them to get rid of someone. So I think it comes down to a recipe for injustice.
That expression you used about the boss saying whichever way you can get rid of them, use that to get rid of them. And I think that's the sort of thing that happens again and again. It goes back to this Harrow thing. Somebody's just said, no, we're not going to house him, and use priority need, use vulnerability. And then when they get then the reviewing officer says, I've got to overturn this, and they say, well, it was only the letter that was wrong, it wasn't the decision. I mean, it's one of those crazy ideas that you could have a letter it was just the wording, but the wording didn't actually affect the decision. But anyway,
the good news with Harrow is, just very quickly, is that it's got a relatively short waiting time for single people. I think it might be the shortest waiting time in the whole of London for people getting housed once the main housing duty has been accepted. So hopefully once you actually win the argument with them, it won't be that long before the guy's housed.
Good. Well, I'll let you know what happens with that one. And so I think that's I think we've done a whole hour. It's gone by very quickly, and thank you all for taking the time again. And again, I think I'll try and put what I'll try and do with these materials is I'll try and make videos so that I'm not just taking up time on a live stream with me just delivering a presentation, and then we can maybe people can watch that, and then we can have a discussion after that, if that makes sense. That's how I'd like to do it. If I just manage to live on 2 hours sleep a night, I'll be able to do that. So thanks everybody. See you. Are we on for Thursday? Great.
Yeah.
Okay. But I'll say goodbye. Perfect
I think
timing.
Shannon's not, but yeah, I think.
I won't be there Thursday. Sorry.
Oh, okay. Well, sorry. I'll see you maybe next Monday then. And so I will.
I won't be here next Monday either. Sorry.
Oh God, well, next Thursday week. But anyway, whenever we see you, it'll be really nice to see you again. And I'll end the show for now.